Good evening, everyone. For those that I haven't met, my name is Yuri Chumak, and I'm the moderator of today's webinar. The title of today's webinar is The Elephant in the Room, Choosing the Right Executor. In this webinar, we will explore the key qualities and qualifications to look for in an executor, the pros and cons of different types of executors, and best practices for communication and documentation to ensure a smooth and successful estate administration. This subject is of great importance as the executor plays a pivotal role in ensuring that your final wishes are carried out efficiently and in accordance with your intentions. An executor's responsibilities typically include identifying and gathering your assets, paying any outstanding debts and taxes, and ultimately distributing the remaining assets to your beneficiaries according to your will. Selecting the right executor is paramount, as their actions can greatly impact the speed and efficiency of the probate process, as well as the preservation of family harmony during a challenging time. By way of background, I'm a member of the board of directors of Yvonne Franco Homes. By training, I'm a lawyer practicing with firms in Toronto for over 15 years. This seminar was organized by the communications committee of our homes. And by way of housekeeping, I want to let you know that everyone has been muted. We will have questions after our two speakers have finished their presentations. Now, if you have any questions, you can enter them in the Q&A section of Zoom, which is at the bottom or in some cases at the top of your screen. Again, you can post your questions in the Q&A section of Zoom. This session is being recorded, so it can be shared with others who aren't able to attend today, and the materials will be available to participants. Now I would like to introduce our two speakers. I will introduce them both and then let our first speaker take it away. It is with great pleasure that I introduce our first speaker, William or Bill Petruck. As the founder of Funding Matters, established in 1997, Bill has extensive experience working across various sectors and is highly regarded for his ability to navigate multidisciplinary and complex initiatives in raising funds for capital and endowment projects. His work spans diverse populations and disciplines, including health, post-secondary education, social services, cultural heritage, economic development, and green energy. Throughout his career, Bill has collaborated with private sector, government, and voluntary organizations, sharing his expertise at numerous conferences and educational institutions. He is a University of Toronto graduate and a great advocate of philanthropic giving to benefit society. Please join me in welcoming Bill Petruck as he shares his valuable insights on our topic today. Our second speaker is Laura Ross. With an impressive background spanning over 30 years in financial services, Laura brings a wealth of experience and knowledge to our discussion. Throughout her distinguished career, she has successfully guided families in planning for and executing estates across 5 countries, all while offering her services at a fraction of the cost typically associated with legal services. His unique expertise and dedication to accessible estate planning make her an invaluable resource in today's exploration and discussion regarding the crucial aspects of choosing the right executor. Join me in extending a warm welcome to Laura Ross as she shares her insight on this important topic. Now I will ask Bill Petruck to take over as the first speaker. Over to you, Bill.
Thanks, Yuri. Good evening, everyone. Very excited to be presenting alongside Laura. Laura is a tremendous resource and asset, and I'm very pleased that she can join us. One of the things that, as Yuri has indicated, my background in philanthropy and philanthropic giving is an area that I often get into a conversation with families, and that is, hey, do you have a current estate plan? Do you have a current will? And invariably, the answer is usually no, we haven't updated our will. No, I haven't. We've had some changes in our lives, but they have not been incorporated in any of the documentation as we move forward. So that always is a good starting point for getting people to start thinking about their estate plans, who their executor may be. And the fact is that 60% of adults over the age of 50 in North America don't have a current estate plan. So there's a lot of money that's being left on the table. And one of the aspects of that is that we all here and across the country love, as we're filling our taxes out, writing checks to the receiver general. So if you like doing that, don't update your will. Just leave it the way it is. But if you do want to make a difference with your assets that you have grown, that you've worked hard over, that consider incorporating, updating your will, updating your executors, and incorporating a charitable bequest that may offset some of the taxes that you'd pay. Now, when we talk about estates and estate planning and executors, with a week doesn't go by where we don't have one of our clients come to us and tell us a story of something that has gone wrong with somebody's estate. And today was no different. Last week was another situation. And in many cases, the person who's the executor of the estate wishes that they were never appointed executor of the estate. And it reminds me of a Mark Twain quote that said, "The more I learn about people, the more I like my dog." And it's every executor would say, "I wish I never became executor on this estate." And it's because when the friend, the person that I knew, the family member died, I was left to make the funeral arrangements. I was left to obtain the copies of the death certificate. I was left to identify the assets and the liabilities and make a full determination of what the net outcome of that would be, what the taxes would be. I was left to create and maintain the records for the estate. I don't know where I was going to find the time to be doing all of this, but this is what's being dumped on me at this point. I had to communicate to the beneficiaries regarding the distribution and management of their estate. I had to retain a lawyer to advise on the administration of the estate. I had to satisfy the debts and the obligations of the estate, not only in Canada, but outside of the country. I was responsible for the accounting of the administration of the estate. I had to think carefully how did I end up as the executor of this estate? And lo and behold, I never thought that I would outlive the deceased. I never thought that I needed to have the mental competency to be doing this. And here it is all on my plate. And so when we start to think about the role in selecting an executor, the role in figuring out what the next steps should be, there are so many things to take into consideration. And today's session is an important step for families in general to maintain family harmony, family unity, and an understanding of what that individual had in mind with their estate and the administration of it. So there are so many different levels and layers to this, to peel back on this onion. And we're really fortunate to have somebody like Laura here, who's had extensive experience in her background from the financial side, the investment side, to actually hand-holding many of these families and walking them through, more importantly, while the individual is still alive and can convey and communicate what's important for them. So with that, I really want to use this time wisely and turn it over to Laura. So Over to you, Laura.
Thank you so much, Bill and Yuri, for inviting me to speak to everyone. I look forward to hearing some great questions later on in the session, but I thought I would start, and I really appreciate, Bill, the things you said about family harmony, because that really speaks to why I started getting into this business. And I just want to give you a little bit of a background, and then I'll go into some examples and some things that I look at in estates that can really help people to minimize family conflict as much as possible. My background, I've worked in financial services the majority of my career, and most recently I was a chief operating officer at a small investment counsel firm. And I saw firsthand what happens to people when someone dies, whether someone passes away suddenly or it's expected. Families are often thrown into turmoil when someone passes away, and they're just not sure what they're supposed to be doing. It's obviously an emotional time, and people are not thinking clearly. So from a personal perspective, my mom passed away a long time ago, and I ended up becoming my father's power of attorney and executor. And with my background in finance, I also have an MBA in finance. So I thought this should be easy. And I was shocked. I was shocked at how difficult it was, how onerous it was, how many small detail things were required. But more importantly, I was shocked by the lack of direction I was being given by the various financial institutions. I would walk into one bank branch and they would tell me one thing, and I would walk into another bank branch and they would tell me something totally different. And I still to this day am quite surprised that, given the fact that we are all dying, you know, that's the elephant in the room. It's just a timing issue. And what is it? What is the plan for people? How are people supposed to navigate this whole area? So as a result of me helping my dad in my role as executor for his estate, I just kept thinking, who's helping people in this role? So I decided to start this business for that purpose. It was really to help people. And I took a course called the Certified Executor Advisor, which, you know, to try and round out my knowledge. But to be honest, every estate I've worked on, I've learned a lot. There's no consistency to anyone's estate. They're all so different. So I started this business about 8 or 9 years ago, and I've met so many fantastic families and learned so much. My initial thought in this business was, I will help people in their role as executor. If they don't have anyone to help them or they need assistance, I will take that on. Now, after a couple of estates, it became extremely clear to me that, you know, a lot of the work needed to be done well ahead of death. What was the person's intention? What were their plans? Because when you think about it, the word executor means to execute. So the executor should have been given so much direction in what they're doing that they really should not be making that many decisions. They should be simply carrying out the wishes of the person who's passed away. So the way that I view estates, kind of to reiterate what Bill was saying, is that regardless of the wealth that any of us have earned over our lifetimes, that our goals are all the same, which is to try and reduce or eliminate family conflict as much as possible. We would all hate to think that something we are doing in our estate or have set up in our estate may cause our children, our loved ones to fight after we're gone because we hadn't thought about things thoroughly. So the way that I look at estates are kind of in 3 components. I look at health directives, I look at your financial wishes, and then overall estate goals. There are a lot of people that, you know, will help with financial plans, but to me, that's really just one aspect of estates. There are a lot of issues around health directives too. What is it that what are your wishes? What are your beliefs? What are your values when it comes to your healthcare? What's important to you? So one of the things I thought we would talk about today, and I do want to get to the role of executor because that's very important, but I want to make sure that I leave you with a couple of key and salient points about things that you can do in your own estate to get more organized. And I believe Yuri will be sending around my contact information after the presentation. So if anyone has further questions or would like assistance getting their estate organized, I call it getting your ducks in a row, I would be happy to help. So some of the things that are kind of the key areas of estates that I see are big, kind of the big ticket items are powers of attorney. So there are two types of powers of attorney. There is power of attorney for care. So really, what does that mean? It basically means that, I'll give you an example. Someone falls down the stairs and has a head injury. Maybe it's a short term, maybe it's longer term, but they can no longer make decisions for themselves with respect to their care. So a power of attorney for healthcare is someone that will accompany the person to medical appointments, make decisions about how their health directives should be taken care of. So some important things around that are, have you told your power of attorney for care what's important to you? Do you have a do not resuscitate? What does it say? Does your power of attorney live near you? You know, there are lots of areas that people fight about, and oftentimes we believe that it's about money with respect to estates, but it can also be with respect to the way someone's life is looked after and whether they have that extra surgery, whether, you know, they're moved into palliative care or whether they stay in their own home. So I help clients, you know, try and navigate those difficult issues. What does their do not resuscitate say? You know, you don't want your family trying to second guess what your wishes are, and you don't want them bringing their own beliefs in with respect to how you would like to be handled with respect to your health directives. There's also a power of attorney for property, which is basically dealing with all your financial records and your financial bill payments, etc. So again, that could be a short-term thing. It could be a long-term thing. Who is paying your bills? Who knows where all of your money is, what accounts it's in? Do you have a safety deposit box? All those things. So you have to think very long and hard about who will be the person who will be looking after that for you in the event that you're not able to. So I have some examples of some things, and then I do want to get into the role of executor. But you know, some of the when Bill and Yuri and I were kind of discussing this before, they asked if I could bring some examples of some, you know, things that have happened with some of the estates that I've been working on and where some downfalls have happened. And, you know, not having all of your paperwork in one spot, it makes it extremely difficult for your executor. I always say to executors when I'm, you know, speaking at presentations, is if you have not seen the will of the person that you're supposed to be the executor for, don't do it. Because if you have not gone over that will thoroughly and know exactly what that person wants, how are you expected to do a good job? So having all your documentation in one spot, where are your powers of attorney? Where is your will? You know, how old is your will? Has it been recently updated? Where are the records to your financial statements? Where's the deed to your home? You know, what about all your identification? Where are all those things? So, you know, I often get asked to act in the role of executor, and sometimes I didn't know the person. The kids live outside of the country, and I've been working with a couple of families in Toronto, and finding where all their stuff is it's kind of a daunting task. Where is all their paperwork? I've gone through people's underwear drawers and found safety deposit box keys that no one knew were there. I've gone looking for jewelry that has gone missing and found it in the bottom of a wardrobe. I've found silverware that was tucked away in the bottom of curtains. So we all have our way of doing things, but if you don't communicate about what's important to you and where all your stuff is, how is your executor going to do a good job? One of the issues, again, we were talking about healthcare. One of something that happened to me when I was relatively early on in this business was I started working with a woman in Toronto, an elderly woman who we just had started talking, and we were talking about her healthcare directives, and she was quite adamant that she wanted a fairly detailed do not resuscitate. I would encourage you all to look at your wills and see what your language around your do not resuscitate says. If your will is over about 5 or 6 years, your wording around your do not resuscitate may say, I don't want artificial means to keep me alive. But what does that actually mean? Artificial means can mean antibiotics to one person. It could mean dialysis to another person. So really, what is important to you? So back to this example, I was working with this woman, and she was quite adamant about her do not resuscitate being quite detailed. She had had some health scares and was quite adamant that she, did not want artificial means to keep her alive. She had a bad fall and was rushed to Sunnybrook Hospital, and her daughter was the first person on the scene. The emergency room doctor came out and found the daughter and said, your mom has had a horrible fall. Does she have a do not resuscitate? The daughter said, you know what, I don't have it with me, but I know she was talking with someone about it. I know this was important to her. She does not want to be resuscitated if she's not going to be the way she wants to be. So in the meantime, the doctor goes back into the hospital, the brother comes to emergency, and the mom succumbs to her injuries as a result of the do not resuscitate. So when the doctor comes out to notify the daughter and now the son that the mom has succumbed to her injuries, he says, as a result of the do not resuscitate, your mom has passed. So the brother knows nothing about the do not resuscitate. So he and his sister start fighting in the waiting room at Sunnybrook. And you can see how that can happen. They are not fighting about the do not resuscitate. They're fighting because, and the only person they can take it out on is each other. So, a do not resuscitate is a very simple document that you can discuss with your family members and actually give them a hard copy so that when you're in emergency or in a crisis situation, your power of attorney can simply hand that document over to a healthcare professional. It takes all of the onus off the power of attorney because they don't have to make any decisions. They are simply executing your wishes, which is sending that piece of paper to someone who can actually act on your behalf. So that's, healthcare directives are really, really important. So I do want to talk about, how to bring this up with family members, the whole business of estates. It's an extremely awkward thing to talk about with your loved ones. I have clients who are 70 years old and their parents are still alive. And as long as you have a parent alive, you are still a child. And they're very uncomfortable asking their parents what their estate wishes are. The initial thing we all believe is that it seems like we're being greedy and we want to know how much money are we getting. And excuse me, that's not what the conversation is about. The conversation is about what are your health directives? What is it that you're hoping to achieve with the wealth that you've created? What's important to you with respect to your funeral arrangements? What about all the things that are personal in your life, your paintings, your jewelry, your knickknacks, those things that are maybe family heirlooms that may not have any value, but they have great emotional attachment. What are you doing with those things? Those are the things that people will fight over. And again, oftentimes they're not fighting over a painting or a piece of jewelry. They're fighting because there's some deep-seated issues with their siblings or whatever it is. All families are complicated. Of the many families that I've worked with and estates that I've worked on, there isn't one family where there aren't issues within the family. There always are. And, so to be able to talk about your estate well ahead of death, sitting around the table, having a very direct conversation with your family about what's important to you is extremely important. So I do want to talk about the role of executor, because it's a very important role and it's somewhat misunderstood. As Bill mentioned, there's so much involved in being an executor, and it's getting more and more complicated. to the point now that a lot of executors will actually get executor insurance, particularly if they're not a family member. And that's just to protect themselves because it is such an onerous task to be someone's executor. So first of all, what is the responsibility of an executor? Bill made some great points about some of the things that you have to do. It's shutting down all your bank accounts, canceling all your ID, potentially selling your home, a vacation property, liquidating all of your assets, dealing with all of your chattels or your household belongings, dealing with all the paperwork. In the province of Ontario, the recommended time frame for an executor to wind up an estate is a year. But right now in Toronto, for example, it's taking about a year to actually even obtain probate. So it's impossible to get an estate wound up within a year. So just imagine that you're giving that, someone, whether it's a family member or someone else, you're giving them a tremendous amount of work that, that could take the better part of a year or two to actually do. So one of the things that a lot of people don't know about executorships is, again, in the province of Ontario, an executor is entitled to 5% of the value of the estate. Is that the right number? I don't really know. A lot of executors don't take a fee for acting in that role. A lot of them don't even know that this is something that they can apply for. But it's very awkward, as you can imagine. Let's say you have 3 children and you want to name all 3 because you don't want to hurt anyone's feelings. First of all, if they knew what being an executor was, they would not be upset if you didn't ask them. But again, most people don't know what's involved in being an executor. Let's say you do name your 3 children or 2 children. So the complications of that is that for every document that is signed, for every bank visit, for every, conference call that has to be had about your estate, all 3 of those children have to be involved in everything. One person can't do that role unless you've just named one person to be your executor. Back to, let's say you have arranged for 3 of your children to be your executor. What happens when it comes time for the fee to be distributed? Let's say you have 2 sons and a daughter, and your daughter has done the lion's share of the work. How is the executor fee distributed? If she has done 80% of the work, can she collect 80% of that revenue? It makes it awkward for her to go back and ask her brothers and say, well, I did most of the work. It's just an awkward thing. When I'm acting as executor for people, I charge an hourly fee. I feel, at least for me and my business, that's a fairer thing to do because it's all time related. This whole area of estates, I cannot stress enough. It's kind of like the Wild West. There's very little structure. There isn't an organization or a group of people or really anyone who can assist you with this. Lawyers are very siloed. They will help you with your estate, your will, and they can help with probate. Your accountant will do your terminal tax return and help with the taxes on the estate. Your investment advisor can help get some of your investment accounts, but there isn't really anyone looking at an estate in a holistic way. I really, truly believe there's such a need for that. And I just don't really see that many people helping people overall with their estates. So who else can you ask to be your executor? There are trust companies associated with banks. Excuse me for 1 second. I'm so sorry, I had an alarm preset. So who else can you ask to be your executor? There are trust companies that can do that work. They're typically affiliated with banks, but I work with a lot of investment advisors, and they are often not comfortable recommending their own trust companies at the banks that they work with. I'm not sure if it's a turnover issue or an expense issue or what the issue is. but they would be potentially an option for you if you have a very complicated estate. There really aren't many people helping families and individuals in the role of executor. I really have not found many people who help people. So I'd love to tell you that there is an organization out there that I can recommend, but there really aren't. The most that you could do is potentially maybe name a child, 2 or 3 of your children, and maybe see if a lawyer or an accountant or an investment advisor or a trusted friend could assist them in that role, so that they have someone else to go to ask. So it's certainly not something that is, again, there's a lot of support in. I wanted to talk also about probate and just an understanding of what that is. So when someone passes away, typically if it's a husband and a wife, both members of the couple are still alive. If your estate is structured properly, then oftentimes things will transfer from one spouse directly to the other spouse. Again, if things are set up properly, property can transfer to the remaining spouse. Bank accounts, investment accounts, there are lots of things to do, which again, I would be happy to speak with you about that, so that when the first person passes away in a couple, that the estate will just transfer to the remaining spouse. And oftentimes there's the person who's passed away won't have any estate because there was nothing in their name and their name alone. So when estates really are more difficult is on the passing of the second spouse, because when an estate passes a generation from a parent to a child, that's when it gets quite complicated. So the way that probate works is, so I'm going to take an example of a husband and wife. The husband has previously passed away, so that the wife is remaining. So she is now an owner of a home, maybe a cottage, has a number of bank accounts, investment accounts. And so what makes up her estate? So an estate is every asset that is in that woman's name as of the date of death. So every home, every investment account, every bank account, other than a registered account such as a RIF, an RSP, or a tax-free savings account, those are often outside of an estate, but everything else is considered part of the estate. So the role of the executor is to determine what the value of all those assets are as of the date of death. Even things like a car, what is the value of that car as of the date of death? What are the chattels of the home worth? Was there an art collection? What is between the jewelry and the artwork and anything else that is in the home? What is that worth? So the executor has to determine what that should be. Something that a lot of people, again, don't know is that while an estate is in probate, so let's say we go back to that, the example of the woman, and let's say her estate between her house and her cottage and her accounts is worth $5 million. So let's say her estate is worth $5 million. So the executor must go through to the province of Ontario, to the probate area. I would strongly recommend using a lawyer to assist, and filing probate and saying the value of this estate was $5 million. The probate fee in Ontario is 1.5% approximately. So the executor has to send a check for $75,000 off with that, with the summation of accounts, and off it goes to the province of Ontario. And then again, in Toronto, it's taking about a year. If you're outside Toronto, it's a little shorter. But so imagine during that year, while you're waiting for probate to be granted, everything for that woman is frozen. So her bank accounts are frozen, her home is frozen, which means you are not able to sell it. You're not able to get any of the money from the bank accounts or the investment accounts. So where that gets tricky, as you can imagine, is if you can't sell the homes, you still have to keep the lights on. You still have to have the driveway shoveled. What about funeral expenses? What if the executor needs funds to, do a renovation or change the house, maybe that needs a new roof to get property insurance. What about property insurance? They have to pay for that too. So again, there are lots of things that you can do well ahead of passing so that all this stuff is organized ahead of time and you have a plan so that your executor knows what the financial responsibilities are and that you've put money aside so that the executor is not paying out of their own pocket for all these expenses before probate is released. So, I was mentioning this again to Bill and Yuri yesterday that I have a client who had a property in another country but had neglected to tell her accountant. And the family ended up having a huge tax bill to CRA because as of the date of death, it's considered a deemed disposition that you have to sell your property. Even though you may not sell it, from an estate perspective, they want to know what the value is, and you have to pay tax on that. So in the example of the client that I was working with, she had a vacation home. The capital gains on that, so the difference between what she had purchased the home for and what it was worth now, it was significant. And so the capital gains is, a tax based on the difference of that. And the family ended up having to sell another property to pay the capital gains on the home that the mom had owned that hadn't bothered to tell anyone. So, being able to look at all of your estate well ahead of death and try and figure out where are those areas that might catch up your family, where it might cause conflict, where there might be, areas of concern. One of the things that a lot of people also don't consider is that there is often a pretty significant tax issue on an estate. Probate is 1.5%. That's relatively small with respect to the entire taxation of an estate. It's really capital gains on property and investments and banking where there can be significant taxes. So, we all use our accountant for annual tax returns, but rarely do we sit back and say to our accountant, if something happened to me tomorrow and I were to pass away tomorrow, how much is my estate going to owe the government? That's a very different number. One of the things that a lot of people don't know is a RIF account, for example, which is an RSP account that rolls over at the age of 71. It's taxed at 50%. So that can be a significant amount of money. And if you're not aware of that, again, what responsibility are you leaving to your executor to try and manage all this? So getting good advice from an estate lawyer, an accountant, your investment person, insurance is a great thing as well when someone passes away. Making sure that all those people know what your wishes are. Are they all on your team to help you with your estate? Because that's really what you need. It's not just one thing that we're looking at here.
Laura,
Yes.
I'm going to intervene because we have a very interesting question that came in that relates to the topic that you just raised. The questioner said that, here's the question. My lawyer suggested that all my bank accounts, pensions should go to my estate versus assigning separate beneficiaries. My banker, however, stated that if I assigned separate beneficiaries, they would not have to go through probate, saving time and money. Appreciate your input. And, if I could just chime in with my thoughts before, as you consider your answer, I wanted to say that, being a lawyer, I would say that your banker and your lawyer are both correct. Or in other words, there are pros and cons to both approaches mentioned by your lawyer and banker. So as far as if I were to consider this question, the pros that I see when you name your estate as the beneficiary is that your assets will be distributed according to your will, providing a clear roadmap for the distribution of your assets. This can simplify your estate administration. But of course, as you mentioned, the con is that you'll have to pay the probate tax, which can be time consuming, expensive, and hold up the, it sounds like the process takes a year in Toronto. In terms of naming separate beneficiaries for your accounts, again, there are pros and cons. Assigning separate beneficiaries can help you avoid probate, and this can save time and money and provide privacy for the beneficiaries and provide quicker access to the money. But the cons, one of the cons that I see is that if you have multiple beneficiaries and assets, managing and updating all these individual beneficiary designations for each account can be complicated, can be time consuming, and you have to carefully coordinate all these different beneficiary designations. So those are my initial thoughts, but I'd love to hear your perspective, Laura.
So I would be interested to understand why the banker and the investment person gave different responses. So, I always kind of take a step back and say, what are your overall estate goals? What is it that you're trying to achieve? One of the benefits of having a named beneficiary for whether it's an RSP or a RIF account or a tax-free savings account, because those are the things where you can have a named beneficiary and insurance policy. One of the benefits is that if you pass away, those funds become available to those people right away. So, for example, an insurance policy, if you name an executor for the beneficiary of your insurance policy, they have funds available right away to pay for, the upkeep of your home, your funeral, etc. So again, I would step back and say why. Perhaps the person, maybe doesn't trust some of the beneficiaries in their will, so wants to have money done outside. There are really a whole bunch of reasons why you would choose either one. The majority of investment advisors that I work with usually recommend that someone names a beneficiary to their RIF, RSP, or tax-free savings account. And the reason for that is simply to avoid probate on those assets and that the funds are available right away. But again, I would say, what is the person trying to achieve with their estate, and is that helping achieve their overall estate goal?
That's very helpful. I'd like to remind our audience that if you have a question, please enter it in the chat function, the Q&A function of Zoom. I see Bill with his perspective coming in.
Yeah, do you know what? Great. It's a great question from the floor. One of the areas, as Laura's talked about, is in the beneficiary designation. So the way we would like to look at it is people like to pay as little in tax as possible. So they're going to try and move their assets in terms of beneficiary designations. The obvious one that gives the greatest tax benefit to the individual would be to designate their registered investment, a RIF, an RSP, and designate that to charity. So there was a story of that that took place probably about 12 years ago. A lovely lady, we were doing a presentation just like this, came up and asked me about her RIF. She told me that she didn't have much longer to live. She had a terminal disease, but she had a very large RIF. Her husband left her, and she was the beneficiary of that. And she wanted to find a way to make a significant impact for something that was important to her. But also she wanted to find a way to minimize the tax that she would owe on her registered investment. So we sat down and we actually constructed something that actually played around with scenarios. What would happen if you left 30%, 40%, 50%? She said, I want to leave the government nothing. So part of the meeting with her was to sit down with her advisors and actually look at making that designation of that registered investment to the charity and charities that were important to her. Secondly, is with a lot of individuals, as I first noted, 60% of individuals don't have a current estate plan. And then following up on what Laura was saying, a lot of the individuals, things have changed so much even in the last 5 years in terms of probates, in terms of the bank acts, and the sale of appreciated assets that are highly taxable. One of the things that people can look at is see the impact that they could have if they left a percentage of their estate to charity. And one of the things that we've always talked about is, if you had 3 kids, what would it look like if you had made Yvonne Francois or another charity or charities your 4th child? What would happen if you put 25% of your estate value into a charitable gift? What would happen if you picked a specific number? How much does your tax owing to Receiver General go down by making this donation? What would happen, and we created something, what would happen if you actually wanted to leave the government nothing? How much would you have to give? How much would your heirs get in the end? Because when you actually play around with those scenarios, you really find that your heirs are not, you're not giving your heirs any less money when you actually factor in that the government is your partner by giving you a tax credit on the tax that you would owe by making that bequest. And you could then start looking at your forward planning in terms of the conversations that Laura would have with her clients, or charities would have with their donors, about how can they be starting to think about making these types of determinations now, that they would see their money at work. So we're trying to really satisfy what the values, the interests, and priorities of the individual happen to be. And we always know that they want to leave as much money to their heirs as possible. And that may speak to the scenario of the question that came up. Secondly, we also want to recognize that as much as they want to leave for their heirs, the government has this expectation of what they're would be receiving in terms of the tax on the capital gains. And then thirdly, is the role that a charitable gift now or a bequest can be incorporated within the estate plan that would satisfy not only that individual's legacy for their heirs, but for the community as a whole.
Yeah, that's a very good point.
That's a great point. We have another question that came in. I'm not sure if this is one for you, Bill, or Laura. The question was, could you tell me more about capital gains? I.e., my mom bought her house decades ago for $30,000. Wow. Today it is worth around $1 million at least. Will capital gains taxes apply? And if so, any idea of the taxes charged?
So that's a great question. And I should have clarified that with respect to when I was speaking about homes. So one of the great things about our tax system, there aren't many, but one of the great things is that your principal residence is not, there's no capital gains on your principal residence. So if your mom's home is her main home and she bought it for 30 and it's worth $1 million now, that entire gain in the value of that asset is fine for your mom. She does not have to pay any gain on that at all, or any tax on that at all.
That's great. There's a question for you, Bill, which is, high net worth families have figured out how to help charities without paying as little CRA by creating family foundations. So are the strategies you describe, are they creating the same result for smaller bequests without having to create a foundation?
Right. So the role of, let me get back, let me sort of talk about family foundations. So since 2008, when the federal government changed the benefits around donations of appreciated assets, that is, that if you bought shares at $10 and the shares are worth $100 and you've got a $90 capital gain on your shares, based on your tax bracket, that would be how much, it would be a calculation how much tax you would owe. So for ultra high net worth families, who have had a significant event take place for them in their business. They've sold a business and they start to look at the taxes that they may owe. One of the ways that they may avoid the tax is setting up a family foundation. For those families for those individuals who may not be looking at mega family foundation assets under management, there are options called donor advised funds. So a number of fund companies offer these vehicles that people can actually set up a donor advised fund for the purposes of tax avoidance, but also for the purposes of charitable philanthropic giving, because 5% of that of the asset under management has to be dispersed every single year for charitable purposes. So you have to be generating more than 5% to be actually coming out with a net number that your asset continues to grow. So the third situation is probably the easiest one to deal with. And that is, if you like an organization, you like what they do, you can understand that your gift from your estate or a current gift from an appreciated asset can avoid tax by that charitable gift to that organization, then you've got an opportunity to be a direct funder to that organization. And that's how the majority of individuals who make major contributions to charitable organizations are by far looking at doing it through appreciated assets. So it's a process. It's not a complicated process. It's a process that you would look at the asset that you have from the institution that's holding that asset. Let's just say it's stock, Air Canada stocks. So you've got your Air Canada shares with your investment advisor, your self-directed fund. You communicate with the organization that you want to direct those shares to, and you transfer those shares from your account, as many shares, one share, or as many shares as you would like to transfer, and you transfer those shares to the not-for-profit organizational investment account. And Yvonne Francois has an investment account with BCU Wealth that can receive and transact that donation for you. And that donation then is sold by the institution, determining the fair market value. And from that is what you get your charitable receipt. So instead of selling those shares and then writing a check, if you sell the shares, then you have to pay the capital gains on that, the tax owing on those capital gains. If you transfer the shares, which is really simple to do, and your institution can actually help do that for you to the charity of choice, that charity's investment account sells them immediately, determining the fair market value. And then you not only avoid the tax, but you also avoid the inclusion of the tax on your income, potentially putting you in a higher tax bracket. So if you sold the shares and wrote a check to Yvonne Francois, that gets included into your income. By transferring the shares, you avoid that being included in your income and putting you in a higher tax bracket. So you're donating and you're getting taxed the lower tax bracket, and you're getting the benefit of offsetting the tax that you would owe on your charitable gifts. If you have any more questions about that, I can walk you through. And on the Yvonne Francois site, there's this application called Gift Tabulator, and you can actually plug in all those numbers and scenarios and have fun playing around with it yourselves.
And we will be sure to send a link to that tabulator as part of the resources after the session. I had a question that came in for Laura, which is, Laura, what are the most important qualities to look for in an executor? Why are these so important?
So I would say, I think we've talked a lot about all the things that the executor has to do. So I would say someone who's detail oriented. The responsibility of an executor is quite daunting. There are numerous things that they have to do. but they also have a fiduciary responsibility to communicate with the beneficiaries regarding what they're doing, keeping track of their expenses, keeping track of everything they're doing. So, you know, having someone be quite detail oriented is extremely important. A good communicator, someone who gets along with, you know, other people well, because again, they may be questioned by some of the beneficiaries as to why it's taking so long. You know, they have to be a bit of a mediator too. So someone with a background in finance is also very helpful. It's tough. I know it sounds like a daunting thing. Yes, I just see the chat. Can an executor be a U.S. resident for a Canadian citizen? No. So not only can a U.S., I mean, they can, but it's extremely difficult. It's even difficult to have someone live in a different province, if you can believe it. So if you die in Ontario, your executor really should live in Ontario as well. The reason for that is there are so many boots on the ground tasks that the executor has to do. I'm often going back to banks 3 and 4 times with different paperwork that they have now decided they need, or, you know, meeting with a banker to try and get something resolved around a RIF payment or whatever it is. So having your executor live in the States, if you do have an executor, and they do live in the States, they typically have to put a bond in place. Some banks in Canada, I've had the experience that they will actually not deal with an executor in the US. So it really should be someone who lives in Ontario. So
we have another question that came in, Laura, which is, what are the key differences between choosing a family member or a friend versus a professional executor? And what factors should be considered when making this decision?
Yeah, that's a good question. You know, again, what is it that you're trying to achieve with your estate? Is there someone in your family who you think could do a good job? Have you communicated your wishes so that, again, all they have to do is execute your wishes? You know, do you have all those things in place? If you do, and the person has those qualities that I just mentioned, so financially aware, organized, a good communicator, detail oriented, then it's great to use a family member. But not all families have someone in their family who has those qualities. You know, oftentimes people say, oh, I'm going to use my sister or a cousin or, you know, my best friend. The challenge with that is if it's someone who's approximately the same age that you are, what happens if they pass away before you do? So you really need to put an alternate in place. And again, there are professional executors at trust companies. I am not aware of any other organization that offers that service for people, which is crazy to me because, you know, again, we're all dying. Who's helping people with this? I don't know who it is. I have been helping people again since I started this business, but I'm just one person, and I'd love other people to join the field because there's such a huge need, and people just don't always have someone in their life who can do a good job. And, you know, to speak to Bill's point, the reason estates are complicated is because people haven't done the work ahead of time and really looked at what is it that they're trying to achieve. Where is all their documentation? Are their accounts set up properly? Are they leaving their executor in a good position? Have they done all that work? Have they communicated and documented as much as possible what they want to happen, whether it's with their health care, their will, their, you know, family heirloom from Aunt Mary, whatever it is? Have they done that work ahead of time? Because if you've done a lot of that work ahead of time and your executor has a well laid out plan and everybody knows what the expectations are, then you're giving them a much easier job to do. So then trying to find that, you know, Svengali of estates is not as necessary because you've done so much work ahead of time. So that's, you know, if there's one lesson that I would say people should take away, it's do the work beforehand. You know, get your ducks in a row.
Well, that, speaking of getting our ducks in a row, it's now 8 o'clock, which is the closing time of our session. I wanted to thank both of our speakers, Laura and Bill. And in fact, and all of the participants today, we had a good number of participants and we had some good engagement. Just a reminder that we will be sending out a survey about the webinar right after the session closes. We'll be including contact information as well for both of our speakers. And video of this presentation will be posted in due course. The next webinar in our series is scheduled for May 27th. And watch for information at the beginning of May about this seminar. The topic will be managing the emotional journey of long-term care. And the speaker will be an author, Deborah Bakhti. And a special note that the first 20 registrants for that webinar will receive a copy of her recent book. And again, watch for information about our next webinar in May. So thank you and have a wonderful evening.